So, welcome to LiberalViewer Wednesday Live. This is the live Q&A show I've been doing every week on Wednesdays at 4:30 p.m. Pacific. This is a great day to be doing a live show because it's a historic day in the U.S. Supreme Court with the two big cases on marriage equality coming down. So I wanted to talk about that for a little bit, and then as usual, I'm going to be taking questions from my viewers here. Questions. Some people have posted questions during the week that I have had a little chance to do some research or thinking on, and then I'm also going to take your live questions here in the comment section. Let me just make sure everybody can see and hear me here. If you're in the comment section, if you could let me know that you can see and hear me, I'd appreciate that. And then I will start. I actually, even though this is my live Q&A show and not the clip roundup show I do on Sundays at 6:30 p.m. Pacific, because this is a historic day in the Supreme Court, I did want to play a couple clips for you that I thought were kind of interesting from some of the coverage of what happened today in the Supreme Court. But before I do that, I'll give a brief explanation of what happened. There were two cases. One was from where I am in California, the Proposition 8 case. And in that case, the U.S. Supreme Court dismissed it on the basis of standing, which means that they decided that the people who appealed the case didn't have standing to sue in federal court. What happened in the case is California passed Proposition 8, which outlawed same-sex marriage after the California Supreme Court had found a right under the California Constitution for same-sex couples to marry. This was an amendment to the California Constitution, and after it passed, neither Governor Arnold Schwarzenegger nor who was then governor, and then Governor Jerry Brown, the current governor, they did not want to defend the law as constitutional. And so the people who put the ballot initiative on the ballot, they're the ones who appealed it in federal court. And the Supreme Court said it has to be the state who's appealing the law. It can't be some private party that they've never found standing for a private party to appeal on the constitutionality of a state law like that. So that brought it back to California, and that makes the district court, federal district court decision by Vaughn Walker, that found Proposition 8 unconstitutional. That is now the operative law in California, and even though it was found on a standing issue, so there weren't any real, they never reached the merits in that case as to whether there was a right for same-sex couples to get married under the Constitution. There were some victories, and I wanted to show this clip from David Boies, one of the attorneys. It was like a combination of a conservative and a liberal attorney. David Boies was liberal, and Todd Olson was the right-wing Republican who they joined together to fight to overturn Prop 8. And so anyway, here's what David Boies had to say about, even though the California proposition was brought back on a standing issue, he said there were some victories, and I wanted to play that clip for you here.
The Supreme Court's decision on standing is important for another reason. When we started out in this case, we said we were going to prove three things. We were going to prove that marriage was a fundamental right, and the other side accepted that. We said, second, we were going to prove that depriving gay and lesbian citizens of the right to marry the person they love seriously harmed them and seriously harmed the children that they were raising. And even the opponents agreed with that. And third, we said we were going to prove that allowing everyone to marry the person that they loved, regardless of sexual orientation, did not, could not harm anyone. And not only did the proponents on cross-examination have to accept that, But today, the United States Supreme Court said as much because they said the proponents have no concrete injury. They cannot point to anything that harms them because these two loving couples and couples like them throughout California are now going to be able to get married.
Sorry, I had a little audio problem there. I thought that was kind of an interesting analysis from David Boies that the standing issue actually did kind of have something to do with the merits. What he's talking about there is that in order to have standing in federal court, you have to show that you've suffered a harm. And so what he's saying is by not finding standing in this case, the Supreme Court saying that these individuals who who sponsored Proposition 8 in California, they're not harmed in any way by these same-sex couples getting married. And so I thought that was a really interesting look at the same-sex or the standing issue, the way it was decided, that it actually does have some effect on the merits. Now, I noticed that the losers in the California case, the Prop 8 case, were not quite as magnanimous as you might hope, and they seem to be kind of minimizing what the Supreme Court decision meant. And I saw an interesting clip on CNN where they showed one of the plaintiff lawyers trying to say that the decision doesn't mean that there's going to be same-sex marriage in California, which is kind of ridiculous from my analysis of what's going to happen. And also, Wolf Blitzer in the Situation Room had Kamala Harris, who is the Attorney General in California, and played her a clip of what the plaintiff's attorney said. And I wanted to show you that and her reaction in this clip.
Today I interviewed Austin Nimitz. He's the co-counsel. He was the one who was supporting Proposition 8 before the Supreme Court. And this is what he said to me. I'll play a little clip for you.
The four plaintiffs that brought this lawsuit may have a right to get marriage licenses issued to them, but this was not a class action lawsuit and does not apply statewide. Proposition 8 is the law of the state of California, and because there's no appellate court decision holding it unconstitutional under the California Constitution, which is what controls this interpretation here, Proposition 8 remains the law of that state.
Is he right?
He's absolutely wrong. The last ruling by Judge Von Walker was that there would be a permanent injunction basically stopping Proposition 8 from taking effect because it is unconstitutional. And in his ruling, the Judge Von Walker indicated that it would apply directly to the parties before it, including the State Department of Public Health, which oversees each of the 58 counties of California and the work that they do giving out marriage licenses. So it is very clear that in the case of that, in a case that was also litigated in California called the Lockyer case, and also one of the federal rules that combined, Rule 65, that combined, it is very clear to us, after a careful review of the law, that all 58 counties must abide by Judge Von Walker's ruling, and once the stay is lifted, they will each be required to perform marriages consistent with the law, and to do otherwise would be in violation of the law.
So you may think, well, those are two lawyers. That's a he said, she said interpretation of this decision. But one thing you have to keep in mind is what the Supreme Court just decided is that the first guy there talking, the plaintiff's attorney, he does not have standing to decide what's going to happen with this case. And the second person there talking, the Attorney General of California, Kamala Harris, she is the one who does have standing. So if I think that pretty much decides on the he said, she said there, that what she said, that's what's going to happen in California. So that's kind of what happened in the California case on the standing issue. And then there was this other case, the Edie Windsor case, which was a challenge to DOMA, the Defense of Marriage Act, which was signed back in, or passed and signed by Bill Clinton back in the 90s. And it has several different provisions. And the provision that was challenged was the one that said that the federal government would not recognize marriages that were legal in any of the states. And so no federal, there are like 1,000 federal benefits that you get for being married under federal law and federal regulations. And Edie Windsor, the plaintiff in that case, her partner died, and she had to pay an inheritance tax that she wouldn't have, like $300,000 worth of tax she wouldn't have had to pay if the federal government recognized their marriage. And so in the Windsor case, the Supreme Court, by another 5-4 decision, struck down that part of the Defense of Marriage Act and said basically the federal government has to recognize the marriages that the states recognize. Now, there's another part of the Defense of Marriage Act that says that states that don't recognize same-sex marriage don't have to recognize same-sex marriages that people enter into in other states, and that part of the Defense of Marriage Act hasn't been challenged yet. And on that, I did have a few questions that were. And sorry for the clicking, I have to load up some media here. I had some questions that were posted before I started the show here. And one of them, or there were like two questions posted here in the comment section before I started the show from Sean F. It says, now that DOMA has been overturned and Prop 8 dismissed, what cases are likely to appear on the docket to definitely settle the issue of whether states can refuse to recognize gay marriage, and also how will the ruling affect immigration now that federal government must recognize same-sex marriage in those cases? Well, immigration there are a lot of federal benefits that come from immigration for married people, like they can sponsor someone, and now that that part of the Defense of Marriage Act has been struck down using the kind of expansive language that they used, it's pretty clear that the federal government's going to have to recognize same-sex marriages that any states recognize. And so in the immigration context, same-sex couples one who's a citizen should be able to sponsor the non-citizen for citizenship. To answer that specific question. As to what cases are going to come next, well, that'll be they're going to be people who are going to be get married in one state and then move to another state, and the question is, there's going to be an immediate question that comes up. If I get married in California and then I move to Alabama, does the federal government still recognize my California marriage now that I live in Alabama? And then the second question is that other section of the Defense of Marriage Act that says that Alabama doesn't have to recognize the same-sex marriage from California. And those will be two of the quick challenges. The more long-term question is whether the right to marry someone of the same sex is a fundamental right, like the right in Loving versus Virginia, which was the Supreme Court case that found that states couldn't have laws against interracial marriage. And there was some language in the Windsor case that struck down the Defense of Marriage Act that I found a little disturbing on that score. And here, hold on, let me click here. Let me load that up here. Now, this is Justice Kennedy. And he said a lot of things about, how the Defense of Marriage Act saying that the federal government won't recognize the marriage that your state recognizes, that, it hurts the dignity of same-sex couples. It tells everyone that they're like second-class citizens and that their marriages are no good. And that may sound like Kennedy is, willing to go for a actual right for same-sex couples to marry, just like the loving right for interracial marriage, where it's a fundamental right, part of the fundamental right to marry. But there were a couple things in the opinion that made me a little pessimistic, at least as to whether Kennedy is going to be willing to go there. Here's one quote from the Windsor opinion. In order to assess the validity of that intervention, this is the federal government's intervention in the state power of regulating marriage. In order to assess the validity of that intervention, it is necessary to discuss the extent of the state power and authority over marriage as a matter of history and tradition. State laws defining and regulating marriage, of course, must respect the constitutional rights of persons, see Loving versus Virginia, but subject to those guarantees, regulation of domestic relations is an area that has long been regarded as virtually exclusive province of the states. And the opinion goes on for quite a while about how what is one of the big problems with the Defense of Marriage Act is that it is getting rid of the state power to define who can be married and who can't be married. And then later in the opinion, I found this a little ominous. There, I'm going to take a, excuse me, my mouth's getting a little dry, a little Marco Rubio here. I saw in the opinion, they say, the history of DOMA's enactment and its own text demonstrate that interference with the equal dignity of same-sex marriage, a dignity conferred by the states in the exercise of their sovereign power, was more than an incidental effect of the federal statute. It was its essence. Now, that's good that the whole equal dignity of same-sex marriages that people are concentrating on, but look at that part I have there in blue, that it's a dignity conferred by the states in the exercise of their sovereign power. Well, you know, our natural rights, our fundamental rights are not conferred on to us by the states. They're like our natural rights given to us by our creator, you know, life, liberty, and the pursuit of happiness or whatever. For the opinion to say that the dignity of same-sex marriage couples is conferred upon them by the sovereignty of the states, I find that a little disconcerting, a little problematic, at least for whether the author of that opinion, Kennedy, is going to be willing to go along with overturning states that have used their sovereignty to decide against same-sex marriage. Now, of course, that's probably going to take a while to come up through the courts, and we may not have the same 9 justices we have now. And, you know, that's what makes me more optimistic and makes me more think that the right of same-sex couples to get married will eventually become a fundamental right, constitutionally, you know, recognized by the Supreme Court, is because by the time that case gets up there, hopefully we'll have a couple different justices. Maybe the court won't be quite so conservative and reactionary and, you know, tied to, you know, I was going to show you some quotes from Scalia's dissent in Windsor, and I mean, that is just like dinosaur thinking, and I'm hoping, that's optimistically, I think that unlike abortion, which has been like a fight forever, I think that this is moving more, that there's more of an inevitable move towards the recognition of the need for equality. So I'm glad to see the 2 decisions today. I think I would have been happier if there had been a majority of justices to actually say that there is a fundamental right of same-sex couples to get married, just like in Loving versus Virginia for interracial marriage. I would have liked to have seen that. But hold on here. Do I have all this? I wanted to take a couple more questions that I have here that people asked me beforehand. I had, let me just load them up real quick. That's the clicking you hear. Let me see, what is that one? Oh. Okay, so I have a couple more questions that people asked as I was getting ready for the show here. One here came from Megan Marie Fowler, says, asked this back on Monday before all this news of the day, asked, a question for Wednesday. The big news out of the George Zimmerman trial is that his jury will be made up of only women. Is it possible for him to use this fact as grounds for an appeal? Well, I always appreciate criminal justice questions because that is an area where I have like the most expertise legally, because I was a public defender, a criminal defense attorney for several years, and The way that juries are selected, each side gets to they go through and they ask questions of all the jurors. In some jurisdictions, the attorneys get to ask the questions. In others, it's the judge that asks the questions. And then both sides get to challenge jurors. And they can challenge as many as they want for cause. If they can make an argument to the judge that there's some reason this jury can't be impartial, they can make that argument, and then the judge will strike an unlimited number for that reason. And then they have a certain number of peremptory challenges, like I think it may be 10, I don't know in Florida what the number is. And a peremptory challenge is where each side can strike a juror for no reason at all. But there is case law saying that when one side uses a peremptory challenge, the other side can say, wait, are you striking that juror because that juror is of a certain race? That's Batson versus Kentucky. A Supreme Court case said you can't strike people on the basis of race. Or gender. I think, what was that, JEB versus Alabama, if I'm remembering the case correctly. That said you can't strike jurors on the basis of gender. But the way the system works is, so if one side, or it's actually the prosecutor, if the prosecutor, because the defense doesn't apply to the defense because it's not state action for the defense, but the prosecutor is the state, and the state can't strike jurors. I don't know if the defense can, but I don't think they can. But anyway, the prosecutor strikes a juror who's an African American or a woman. The defense can say, I challenge you to give me a race-neutral reason for why you struck that juror, or a gender-neutral reason for why you struck that juror. And then the prosecutor has to give say, I struck that juror not because of their race or their gender, but because of this thing. Well, in the Zimmerman trial, it turns out that there were 2 jurors who were struck by the prosecution, and the defense said, wait, you struck those 2 women, and I want a gender-neutral reason why you struck those 2 women. And the prosecution couldn't give one, and the judge put them back on the jury. I heard that on cable news, and then after I got this question, I went and researched it. That is actually true. There are 2 jurors who were struck by the prosecution, and the defense challenged it on this JEB versus Alabama precedent that says you have to give a gender-neutral reason, and the prosecution didn't give a sufficient gender-neutral reason, and they were put back on the jury. And that means that it's the prosecution who tried to get fewer women, and the defense who asked to have them put back on the jury, which means that the answer to the question there from Megan Marie Fowler as to whether the defense is going to be able to use the all-woman jury as grounds for an appeal is going to be no, because they not only they wanted 2 women put back on the jury. So, to have a ground on appeal, you have to object at the time and preserve it, and then appeal if you don't get your way. And they did the opposite. They actually asked for 2 women to be put back on the jury. So I don't think so. There is no appeal issue, although I think it actually hurts the prosecution if you get one of those challenges, a Batson challenge or a JEB challenge. I think they may all be called Batson challenges, even though that's the racial one. If you get one of those challenges and you lose, that means you have 2 people on, and in this case, a 6-person jury, who know that you tried to take them off, and then the defense got them put back on. And that is not a good way to start your relationship with a third of your jury. So thank you for that question, Megan Marie Fowler. I hope that answers it for you. And then I had one more question beforehand, and then I'll take questions in the discussion section. This is a question from Terry Alther there, who's asking me about James Clapper. Question for Wednesday. Many Americans believe... I'm sorry, I have to take a little sip of water while I have this up. Many Americans believe that James Clapper should be tried for lying to Congress. How realistic is this view? I was extremely curious because the Washington Post fact checker rated his claim 3 out of 4 Pinocchios, meaning that his statement was not truthful. But wasn't bad. See more. And then he gave a whole bunch of links, even a petition. I couldn't fit them all in there, but a petition asking for him to be, I can't remember if he's fired or tried. And for those who don't know what this is about, I think I can find this real quick. Load this up. Let me see. Last March, James Clapper was before Congress, and he was asked a question. Oh, sorry, I have still the question up. He was asked a question by Ron Wyden about, and this is before the whole Edward Snowden revelations. He was asked this question, and I'll show you the clip. I have it loaded up here. And anyway, this is what Ron Wyden asked, and James Clapper answered. And he's a chief, a NSA chief. Anyway, here's the clip.
Last summer, the NSA director was at a conference, and he was asked a question about the NSA surveillance of Americans. He replied, and I quote here, "The story that we have millions or hundreds of millions of dossiers on people is completely false." The reason I'm asking the question is, having served on the committee now for a dozen years, I don't really know what a dossier is in this context. So what I wanted to see is if you could give me a yes or no answer to the question, does the NSA collect any type of data at all on millions or hundreds of millions of Americans?
No, sir.
It does not.
Not wittingly. There are cases where they could inadvertently, perhaps, collect, but not wittingly.
So I've shown that a few times now in live events, and that's pretty clearly not a true statement. But one thing I would say is that there's a big difference between saying something that's not true and being guilty of perjury or making a false statement to Congress, which is also a crime under federal law. There are a lot of extra elements besides just saying something that's not true. You have to like willfully and knowingly, and he's made some statements afterwards saying he was thinking that we collect the books. It's like the Dewey Decimal System, and we collect the books, but we don't take the books off the shelf. Or he had, and it was like the least untruthful thing he could say. And then also on the, perjury is a very difficult charge to prove. And then lying to Congress, you actually have to mislead Congress. And Congress was supposedly being briefed about the program at the same time that this, before and after this testimony. Now, I don't want to let him totally off the hook. I think what he said there was wrong and dishonest, and especially when you look at his answer afterwards. But of all the things, I don't think that he's going to end up being prosecuted, especially because the person who would have to decide whether to prosecute him would be Eric Holder or someone who works for Eric Holder being the Attorney General of the United States. So I don't really see that happening. The only way would be if there was some special, there used to be a law saying that special prosecutors were automatically appointed when a judicial panel found a conflict, but that expired, and now it's basically up to the Attorney General to decide to appoint the special counsel, and so it's only political pressure that would cause that to happen, and I just don't see that happening. I'm a little surprised at how the political pressure has been kind of dying down over the whole NSA spying thing. A lot of people don't seem to care, I think even polls show most people don't seem to care that much about the NSA spying that's been going on. So I find that kind of disturbing there. So I don't know, Terry, if that answered your question. I know you posted several links there, which I did look over, but that's my answer to that question. And I did want to take a quick look here at, I'm at about the 30-minute mark, but I can go for a few more minutes. I see I have a bunch of people watching and a bunch of people asking me questions, so I want to go through and look at those. Go back to the very beginning. I saw there were a whole bunch of post here by InfoDirts at the beginning saying, wondering why Republicans seem more politically astute in getting what they want from the 2000 election, Citizens United, Supreme Court decision on Voting Rights Act, even after 8 years of unpopular Bush administration, the economic recession, and the domestic policy, they somehow managed to remain relevant. And I don't want to go through and read all of them, but I'm not sure I agree with that premise about Republicans being so successful. I think that one of the reasons Republicans have remained have power is because of the way the Congress is set up, that because they won a bunch of elections in 2010 at the time of the census, they've gerrymandered a bunch of congressional districts so that even though they didn't get a majority of the votes of people for Congress, they still won the House of Representatives. And I think it's going to be a long time before the Republicans win the presidency or the Senate, even maybe, I'm not sure, but at least the presidency, based on where they're headed now, because they seem to be headed for irrelevancy if they don't make some big changes. Now, I actually think they are going to make those changes, maybe not by 2016, but I've seen, parties, I was a kid when McGovern lost to Nixon, and it was a long time before, Nixon, the Watergate troubles got Jimmy Carter elected, but then there was 8 years of Reagan and 4 years of Bush before we saw Clinton. So, there was a long period of Republican presidents there too, where Democrats were supposedly weak on communism and weak on defense. And I remember like the years of Michael Dukakis and anyway. So parties can go down, and but I think it's kind of a pendulum, and it swings back. And I'm gonna look at a few more questions here. I may not take them quite in order here, but William Tobin asks about with the statement President released yesterday on global warming, has he done enough, and why is he only using executive power? And then I think there was a follow-up question there. It was, shouldn't global warming be such a priority level that it's at the top of the agenda? Well, I think what Obama's doing on global warming, and his speech got kind of overrun by Supreme Court news, but hopefully he'll keep up with that, is there was another Supreme Court decision that said, sorry, my mouth's getting a little dry. I'm going to do a little Marco Rubio again. And for those who don't know, I'm trying to popularize that phrase because I think Marco Rubio is running for president, and I want people to Google his name and see a surreptitious drink of water as like the number one result. There are a lot of people, I think, who are trying to do that. So anyway, on the global warming thing, the reason he's using executive power is because there's no way he's going to get anything through the Congress in terms of lowering carbon emissions. Or I think there was some sort of increase in CAFE standards, which is the mileage that cars have to get. They do it by fleet averages and for the different car manufacturers, and I think they did get those raised up a couple years back. But the way the Congress is working now, the only thing that Obama can do is what I was saying the Supreme Court allowed the EPA to do, which is to regulate the amount of carbon in the air as a dangerous gas. And so he's using his authority, his regulatory authority through the EPA to do that. And that's basically all that's going to get done as long as there's a dysfunctional Congress, which it seems to be there's going. The only things that might get passed, big things anyway, that might get passed before the 2014 election, I think, the comprehensive immigration reform, and that's kind of teetering on whether, it's going to pass the Senate, and then it's kind of teetering on whether it's going to pass the House of Representatives or not. And then there's some talk about the background checks may come back up again before the election, and I doubt that they're going to pass, but I think that that's going to be more of a long-term issue that people are going to use to, for a long time, the NRA has used the gun issue to get in congressional elections to try to knock off people who disagreed with their positions. But I think that there's now going to be many millions of dollars spent on the other side to try to knock off people, especially Democrats, unfortunately. But that's the way it's going to work out. Democrats who fail to support the background checks are going to see a lot of ads run against them by this coalition, the coalition of mayors. I can't remember the name that New York Mayor Michael Bloomberg started. So, but regulation of carbon emissions, that is not going to pass the Congress anytime soon, I don't think. So I'm going to look for, well, I hear hooray for equality, and Pat's Rule 213. What do you think of Edward Snowden and on marriage equality? I'm for gay marriage. People should have the right to marry whatever you want here in America. Well, Pat's Rule, what do I think of Edward Snowden? Well, I think that I don't like the bipolar decision that a lot of the media wants me to make as to whether he's a hero or a traitor. So I think he's somewhere in between a hero or a traitor, and I don't think that he should really be the issue. I think that the stories that the information he disclosed, those stories should be the focus in the Washington Post and the Guardian, and I wish more people were worried about that. And I still think that that's going to be my next video. I'm still working on a video about impeach Obama for NSA spying, so I'll let you know more about that. Let me scroll up here. I'm almost done, but I wanted to take one or two more questions here, if I can find some that I can answer. Oh no. I see some anti-gay slurs in the comment section. Who would have thought? Sean USD, he said, LV sent me a good article earlier in this week. There are no trolls, just bigots. I recommend it after the show, of course. And if you look at my Twitter feed, twitter.com/liberalviewer, if you scroll down, I think I tweeted that to Sean USD. I don't recognize, I think it was a different Twitter name, but you can find that in my Twitter feed if you go check it out. That was a Slate article I thought was worthwhile. I also, there's a good long frequently asked question article right below me here in the video description. You should even be able to see it before clicking show more. There's something from the ACLU of Northern California that talks about all the ramifications of that was just updated about all the ramifications of same-sex marriage law especially for people in California. And then below that you can see, I think there are 5 videos I've made over the years on same-sex marriage equality, those kind of issues. The earliest one is gay marriage a two-sided issue, or I can't remember, is it a two-sided issue or one-sided issue? I actually took some live video at a anti-Prop 8 event way back when Prop 8 was on the ballot. So, and I said back then that I really think that the right of same-sex couples to be married should be a fundamental right recognized under the Constitution, just like the right of interracial couples to get married was recognized as a fundamental right under the Constitution in Loving versus Virginia. I think that will be the ultimate result in the Supreme Court, and hopefully there won't be some case finding something different. That I think this is sort of like a holding action by the old guard in the Supreme Court, and eventually the day will come when we can say there is a constitutional right for same-sex couples to get married as a fundamental right, just like in Loving versus Virginia for interracial couples, and it'll be the law of the land, all 50 states, and that'll be a good day. But today was also a good day. I hope you all thought it was a good day, and I'm glad it was a Wednesday so I could do it on Liberal Viewer Wednesday Live. I hope you enjoyed the show. Next Wednesday will be my last weekly Liberal Viewer Wednesday Live. After that, I'm going to start turning it into Liberal Viewer First Wednesday Live, and it'll be the first Wednesday of every month. But I will continue doing my weekly live clip roundup because I think there's more value in that show than just me talking all the time. Although I did show a couple clips today, but I like the Sunday clip roundup because I select out important current breaking news items and I add my commentary, and I think there is actual educational and analytical value in that show. So I'm going to keep doing that every week, and then this show I'll be doing next week at 4:30 p.m. Pacific, and then Sundays at 6:30 p.m. Pacific. And look for my upcoming video, which hopefully in the next few days will be my video, Impeach Obama for NSA Spying. Thank you all for joining me. I hope you enjoyed the live show, and I'm going to sign off now and go take the dog out for a walk.